The whole idea of fundamental rights, those basic things everyone should just have, it's really the bedrock of any decent society, isn't it?
Absolutely. It defines how people live together, how the state treats its citizens.
And today we're going right to the source. We're looking at how Ghana defines these rights in one of its key documents. We've got excerpts from a chapter called Fundamental Human Rights and Freedoms.
Exactly. Think of it as the foundational contract. And our mission here is to really unpack what's in this chapter. What protections does it actually guarantee you, the listener? What are the limits? How are these rights supposed to be upheld?
Okay, let's dive in then. Article 12 seems like the place to start. It feels like the big overview.
It really is. The main thing from Article 12 is that these rights aren't just nice ideas on paper. They are legally enshrined. They have to be respected
By everyone.
by all branches of the government, the president's office, parliament making laws, the courts interpreting them, and importantly, by all other people and legal entities like companies within Ghana.
And you can actually do something if they're not respected. It says enforceable by the courts.
Precisely. That's the teeth. If you feel your rights have been violated, you have a legal path. You can take it to court.
Yeah, that makes a huge difference.
It does. It means these aren't just aspirations.
What really jumps out at me is the emphasis on universality. It explicitly says every person in Ghana gets these rights. Doesn't matter about race, origin, politics, color, religion, gender.
It's a powerful statement. It anchors the rights in basic humanity, not in someone's background or status. But there's always a but, isn't there?
You mean that bit at the end, where it says these rights are subject to the rights of others and the public interest?
Exactly that. Your rights end where someone else's begin, essentially. And sometimes the needs of the whole community have to be considered. It's a balancing act. We'll see this tension come up again and again.
Okay, makes sense. So let's move to maybe the most fundamental right of all. Article 13, the right to life. Starts off pretty clear. No person shall be deprived of his life intentionally.
Stark, isn't it? It sets an incredibly high bar. Life is paramount. But like many rights, it's not absolute. There's a specific exception mentioned right away.
The death penalty. If a court imposes it for a crime under Ghanaian law.
Correct. That's the primary lawful exception explicitly stated.
But then it lists situations where causing death isn't seen as a violation. What are those?
Article 13, Clause 2 clarifies this. It covers things like death resulting from a lawful act of war. Tragic, obviously, but legally distinct.
Right.
And then there's the use of force that's deemed reasonably justifiable.
Okay, like defending yourself or your property, or maybe a police officer making a lawful arrest or stopping someone escaping.
Exactly.
Yeah.
Those kinds of scenarios. Also things like suppressing a riot or mutiny or trying to prevent a serious crime.
The key seems to be that phrase reasonably justifiable. It suggests the force has to be, well, necessary and proportionate, right?
Absolutely. It can't be excessive. It has to match the specific threat or situation at that moment. That's the critical test.
Okay. Let's talk about Article 14 then. Personal liberty. Freedom from being locked up arbitrarily. Hugely important.
Couldn't agree more. This article basically says you have a right to your freedom, not to be detained without a proper lawful reason. And then it gets very specific about what those lawful reasons are.
And it's quite a list. I mean, serving a court sentence, obviously. Contempt of court.
Yeah.
Like ignoring a judge's order.
Right, but it also covers situations aimed at protection, like detaining someone with a dangerous infectious disease to protect the community, or someone suffering from, say, severe mental illness or addiction for care or treatment.
Also for the welfare of minors, under 18s. And things like immigration control preventing unlawful entry or arranging deportation.
And the big one, really, detaining someone on reasonable suspicion of committing a crime or being about to commit one.
That reasonable suspicion part feels like it needs strong safeguards, doesn't it, to stop it being misused?
It absolutely does, and Article 14 builds those in. Crucially, if you're arrested or detained, you have to be told immediately why.
In a language you understand.
Yes, that's specified. And you also have to be told right then that you have the right to a lawyer, your own choice of lawyer.
Knowing why you're held, getting legal help from the get-go. That seems vital.
It is. And there's a strict time limit, too. If you're arrested or detained, maybe on suspicion of a crime, and you're not released,
Yes.
you must be brought before a court within 48 hours.
Yeah.
48 hours.
Wow. That prevents just being held indefinitely without seeing a judge.
Exactly. It forces judicial oversight quickly.
What if you are held, but your trial keeps getting delayed?
Yeah.
You can't just sit in jail forever waiting, surely.
No. Article 14, Clause 4 covers that. If you're not tried within a reasonable time, you have to be released. Maybe unconditionally, maybe with bail conditions to ensure you show up later. Detention isn't supposed to be the punishment itself.
And there's compensation if you are unlawfully arrested or detained.
Yes, Article 14.5. It provides a way to seek redress if the state got it wrong. And if you are eventually convicted, any time you already spent in lawful custody before the trial has to be considered in your sentence.
That seems fair.
It avoids double punishment, in a sense.
There's also that bit about getting compensation if you're acquitted later on appeal after already serving time.
Right, Article 14.7. If your conviction is overturned, there's a process, potentially involving the Supreme Court, to get compensation. It acknowledges that sometimes the system makes mistakes, even after a trial.
Okay, let's shift slightly. Article 15, respect for human dignity. This feels like it underlies everything else.
It really does. Clause 1 is simple but profound. The dignity of all persons shall be inviolable. Full stop. It sets a fundamental standard of treatment.
And then it gets specific about what's not allowed. Torture, cruel, inhuman, or degrading treatment or punishment. Things no one should ever face.
Absolutely forbidden. And Clause 2b goes further. It prohibits any condition that detracts from your dignity and worth as a human being. It's quite broad.
I also saw it mentioned separating unconvicted people from convicted ones and keeping juvenile offenders separate from adults.
Yes, Clauses 3 and 4. It recognizes they're in different situations, legally and practically. It's about preventing harm and negative influence, treating people appropriately based on their status.
Okay, then Article 16 hits slavery and forced labor head-on. Just completely prohibited.
Unequivocally. Slavery, servitude, forced labor, all banned. It aligns with basic international human rights standards.
But it does clarify what isn't considered forced labor. Seems reasonable. Like work ordered by a court or military duties.
Exactly. Clause 3 lists these exceptions: court-ordered labor, duties in the armed forces, or an alternative if you're a conscientious objector. Also, labor needed during an emergency, like a war or natural disaster. And reasonable community work, like a local cleanup drive.
Right, things that serve a clear public purpose or are part of civic duty.
The definitions are careful, aiming to prevent loopholes while allowing for necessary obligations.
Article 17, then. Equality and freedom from discrimination. Absolutely central, you'd think.
Foundational. Clause 1. Everyone is equal before the law. Simple statement, massive implications. Then Clause 2 lists the grounds where discrimination is forbidden.
Gender, race, color, ethnic origin, religion, creed, social status, economic status. Pretty comprehensive.
It covers the main ways people have historically faced unfair treatment.
And the definition of discriminate in Clause 3 is interesting. It's about treating people differently only or mainly on those grounds, leading to disadvantages for some or privileges for others.
Yes, the link to those specific characteristics is key. But then Clause 4 introduces exceptions, places where Parliament can make laws that might look discriminatory on the surface.
Like affirmative action type laws, to fix past imbalances in society, education, or the economy.
Precisely, that's one major category. Also, laws about personal matters, adoption, marriage, divorce, inheritance, which might differ based on custom or religion.
And rules for non-citizens regarding things like owning land or certain political activities.
Yes, that's allowed, and even different rules for different communities if their specific circumstances require it, provided it fits the Constitution's overall spirit.
So it's trying to balance the ideal of absolute equality with the reality of specific needs and historical context.
I think that's a good way to put it, and Clause 5 just clarifies that anything allowed elsewhere in this chapter isn't suddenly discriminatory under Article 17.
Okay, Article 18, privacy. Your home, your property, your mail, your communications. Feels very personal.
It is. Clause 1 confirms your right to own property. Clause 2 protects the privacy aspect, preventing interference with your home, property, correspondence, or communications, your private space.
But again, not absolute. There are exceptions.
Yes, the familiar pattern. Interference is allowed if it's lawful and necessary in a free, democratic society for specific reasons.
Public safety, economic well-being, health, morals, preventing crime, protecting other people's rights. The usual suspects, sort of.
They are the common justifications for limiting rights, yes. It's about that balance, again, individual privacy versus legitimate societal needs.
Right. Now, Article 19, fair trial. This one looks incredibly detailed.
It is, and rightly so. If the state is accusing you of a crime, the process needs to be scrupulously fair. It starts with the right to a fair hearing within a reasonable time.
And then a whole list of specifics for the accused. Trial by judge and jury for serious crimes, with rules about unanimous verdicts for the death penalty.
Yes, very specific procedures there. And the absolute bedrock, presumed innocent until proven guilty.
You have to be told the charges, clearly, in a language you get, given enough time and facilities to prepare your defense.
Absolutely. The right to defend yourself or have a lawyer, the right to question the witnesses against you and call your own witnesses under the same rules, access to a free interpreter if needed.
It really covers the key elements you'd expect for a fair fight in court.
It does. It even specifies the court composition for treason trials, allows trials in absentia under strict conditions, guarantees a copy of the proceedings. It's thorough.
And no retroactive crimes. You can't be punished for something that wasn't illegal when you did it.
Crucial principle. Along with protection against double jeopardy, being tried twice for the same offense after you've been acquitted or convicted.
Though there are exceptions for appeals, or if, say, you're acquitted of treason but then charged with murder related to it.
Yes, some nuances there. And the right not to incriminate yourself. You can't be forced to testify against yourself.
That's huge.
Fundamental. The article also insists crimes must be defined in written law, generally requires impartial bodies and public hearings for civil cases too, with some exceptions. It's very comprehensive.
And it defines treason, specifically saying that just advocating for change through constitutional means isn't treason. That protects political debate.
A vital safeguard for democracy, yes. It distinguishes legitimate dissent from actual attempts to overthrow the state by force.
Okay, moving to Article 20. Protection from deprivation of property. So the state taking your land or property.
Right. Clause 1 says this can't happen unless certain conditions are met. The taking has to be necessary for specific public purposes.
Like defense, public safety, health, town planning, or developing property for public benefit.
Yes, and Clause 2 insists the law allowing it must show the necessity outweighs the hardship caused. Plus, crucially,
Compensation.
prompt payment of fair and adequate compensation, and the right to challenge the whole thing, including the amount, in the High Court.
What if people are actually displaced, lose their homes?
Clause 3 puts a responsibility on the state to resettle them on suitable alternative land, considering their well-being and culture. It's not just about the property, but the people.
And the property taken has to be used for the reason it was taken.
Yes, Clause 5, only in the public interest or for the stated purpose.
And if it's not used for that, the original owner gets first dibs to buy it back.
Clause 6, that's the first option rule. They can reacquire it, potentially getting a refund of the compensation. It's a check on the state, just acquiring land speculatively.
Interesting mechanism. Okay, Article 21 lists the general fundamental freedoms, a big list.
A really important one. Clause 1 covers freedom of speech and expression, including press freedom, freedom of thought, conscience, belief, including academic freedom.
Freedom of religion, freedom of assembly, like demonstrations, freedom of association, joining trade unions or other groups, freedom of information.
Subject to qualifications, yes. And freedom of movement.
Which includes moving freely within Ghana, leaving and returning, and immunity from expulsion for citizens, though lawful detention obviously limits movement.
Right. And Clause 3 affirms the citizens' right to form political parties and participate politically.
But again, these freedoms aren't absolute. Clause 4 talks about restrictions.
Yes, restrictions are allowed by law if they're reasonably required and demonstrably justifiable in a free and democratic society, for the standard reasons: defense, public safety, public order, public health, protecting others' rights.
Or safeguarding against doctrines that promote disrespect for the nation or incite hatred, but it has to meet that high justification standard.
Correct. And there are review processes for certain restrictions, like those on movement ordered by a court. It reinforces the idea that limits must be necessary and proportionate.
Article 22, then, specifically about property rights of spouses.
Aye.
Making sure a surviving spouse isn't left destitute.
Exactly. Clause 1 ensures a spouse gets reasonable provision from the deceased's estate, even if a will says otherwise. And Clause 2 tasks Parliament with making laws soon.
To ensure equal access to property acquired during the marriage, and fair distribution if they divorce.
Yes. It recognizes marriage as an economic partnership and aims for fairness, especially potentially protecting women who might have been disadvantaged historically in property matters.
Article 23. Administrative justice, making sure government officials act fairly.
Simple but vital. Clause 1, administrative bodies must act fairly, reasonably, and follow the law. Clause 2, if you're aggrieved by their actions, you can seek redress in court. It's about accountability.
Then Article 24, Economic rights. Right to work in good conditions, equal pay for equal work, rest, holidays, joining unions.
It covers core labor rights, satisfactory, safe, healthy conditions, equal pay, reasonable hours, leisure, paid leave. The right to form and join trade unions is key for collective bargaining.
Restrictions on union rights seem limited. National security, public order.
Yes, only if prescribed by law and reasonably necessary for those specific, serious reasons.
Article 25, educational rights. Equal opportunities.
Yeah.
Aims for free basic education, accessible secondary and higher education, functional literacy. Quite ambitious.
Very much so. It sets a clear direction for educational policy. Progressively free and accessible at all levels based on capacity. It also protects the right to set up private schools, following the law.
Article 26, cultural rights.
Yeah.
Enjoying your own culture, language, traditions, religion,
Yeah.
but with a big caveat.
Right. You have the right to practice and promote your culture, subject to the Constitution. And Clause 2 explicitly prohibits any customary practices that dehumanize or are injurious.
So culture doesn't trump fundamental human dignity or well-being.
Exactly. It balances respect for diversity with universal human rights standards.
Okay, Articles 27, 28, 29 focus on specific groups. Women, children, disabled persons. Article 27, women's rights.
Mandates special care for mothers around childbirth, including paid leave. Requires facilities for childcare to help women participate fully. Guarantees equal rights to training and promotion. Aims to address specific barriers women face.
Article 28, children's rights. A lot in there. Care from parents, provision from estates, protection from hazards, protection from harmful work.
Very comprehensive. The child's best interests are paramount. Protection from exploitation, abuse, harmful labor, denial of medical care or education based on beliefs. Defines a child as under 18.
And Article 29, rights of disabled persons. Living with family, participating in society, protection from discrimination, access to public places where feasible, business incentives.
It's about inclusion and dignity, ensuring people with disabilities aren't excluded or treated unfairly, and providing support to help them participate fully. It directs Parliament to enact specific laws, too.
Article 30 seems related. Rights of the sick. Protecting vulnerable people who can't consent from being denied treatment or education due to others' beliefs.
Yes, a safeguard for those unable to advocate for themselves, ensuring their essential needs aren't overridden by, say, religious objections they don't share or can't contest.
Then Articles 31 and 32 deal with emergencies, the heavy stuff. How a state of emergency is declared, the limits.
Article 31 outlines the process. President declares it on advice. Parliament has to approve it within days, time limits, reasons like natural disaster or threats to public safety. Any emergency measures must be reasonably justifiable.
And Article 32 gives rights to people detained under emergency laws. Told why? Access to family lawyer, review by a judicial tribunal.
Crucial safeguards even in emergencies. Prompt notification, review within 10 days, and then every 3 months by judges, right to representation. The tribunal can order release and compensation, and everyone detained must be released when the emergency ends.
So even in a crisis, there are checks and balances.
They are weakened, inevitably, but they are still there. Parliament oversees it, courts review detentions. It tries to prevent unchecked power.
Finally, Article 33, protection of rights by the courts, bringing it all together.
This is the enforcement mechanism. Anyone who thinks their rights under this chapter have been violated can go straight to the High Court.
And the High Court has broad powers to issue orders, habeas corpus, mandamus, all those legal writs to enforce the rights.
Exactly. It gives the court the tools it needs. And you can appeal High Court decisions up to the Court of Appeal and then the Supreme Court.
So there's a full judicial pathway.
Yes. And significantly, Clause 5 says that the rights listed aren't the only rights. It acknowledges other inherent rights that exist in a democracy aimed at freedom and dignity. The list isn't exhaustive.
Right. That leaves room for interpretation and evolution.
Precisely. It acknowledges that our understanding of fundamental rights can grow.
So, wrapping this up, it's quite a detailed picture, isn't it? This chapter lays out a really comprehensive set of fundamental rights and freedoms for everyone in Ghana.
It really is. You see the core principles, dignity, equality, liberty, but also the constant effort to balance these individual rights with the rights of others and the needs of the public. And crucially, the mechanisms for actually protecting and enforcing these rights through the courts.
Hopefully this deep dive has given you, our listener, a clearer sense of these foundational principles that shape life and law in Ghana.
Indeed. And perhaps something to reflect on is how these specific articles, these detailed rules, might actually play out on the ground. Think about a news story involving an arrest or a debate about free speech or access to healthcare. How might the principles we've discussed apply in those real-world situations? Considering that really brings home the significance of having these rights written down and enforceable. It shapes expectations, doesn't it? What citizens can demand and what the state is obliged to provide or protect.